applications or?
Yes,
I mean,
whatever you can do to show me,
because most of
that
them
you're-
are online now.
then print it out, screenshot it, do whatever you need to so that you can bring me proof of what you're doing. Okay, step in front of the clerk, please. Mr. Paget.
Yeah.
I guess I do. Mr. Paget, you have Kenneth Spears?
I'll turn him.
I'm ready.
Okay.
Yeah.
Morning. Mr. Coleman, are you getting as much,
Yes, Judge.
you would think something like that's never happened before.
Smart. Focus on what I need to focus on.
I agree. Same here.
Sorry, Tommy. That's my fault. You know.
It's okay. Good morning, sir. Are you Kenneth Spears? And Mr. Paget, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Getting there. Sorry. And, all right, and we're going on to the full indictment.
Yes, Judge.
That's my understanding, Your Honor.
Mr. Spears, in cause number 25 DCCR 1425, you're charged with the state jail felony offense of fraudulent use or possession of credit or debit cards from July 17th of 2025. Your indictment alleges that you were previously convicted of attempted forgery by possession, a state jail felony, May 1st of 2000. Also, well, it looks like on that same date, 3 offenses of attempted forgery by possession. And then after those were final, you were convicted of possession of a controlled substance, a state jail felony, March 22nd of 2006. 2 cases of possession of a controlled substance on that same date. And then after that was final, or those were final, you were convicted of the state jail felony offense of evading arrest or detention, January 6th of 2014. And how do you plead to the charge of fraudulent use or possession of a credit or debit card? I'm sorry. And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? Speak up, please.
Yes,
And did you plead guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Paget? Do you fully understand them? And it looks like there is not agreement, which means you're leaving your punishment up to the court. And the range of punishment for this offense with those prior convictions would be that of a 3rd-degree felony, which is between 2 years and up to 10 years. And what that means is that I can sentence you anywhere in that range of punishment. You have every right to have a jury come in and decide 2 things. One, if you're guilty or not. And then the second is you could leave your punishment up to that jury. If we go forward, you'll be waiving that. Is that what you want to do? And so there is no agreement. So he does have a right to appeal, but you guys have signed the post-conviction
We have
waivers.
changed things a few times. It's correct. I need to take it back and all.
Judge, the state has no objection to you.
I'll just mark for the
Modify.
Yes, we have no
So
objection.
because there's no agreement, you do have some rights to appeal depending on what happens and you
And that is how-
understand that as well. Do you also understand, if you're not a US citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up, please.
Yes, ma'am.
And it looks like the state is recommending, and of course, we'll see when the pre-sentence report comes back, a 5-year term. You are asking through your attorney for a deferred probation. Is that correct? State tenders number one.
No objections to states one, Your Honor.
It's admitted. Is there any evidence that Mr. Spears is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, this case, your history, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Paget and he will present it to me on your behalf when we come back. All right, you need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right over there. All right, we'll see you back at sentencing.
Thank you, Your
you.
Honor.
Thanks, Judge.
That's what I said, just that. I didn't know if you can call me. So is he in custody? Is Mr. Rojas? And Ms. French and Mr. Rojas? On Mark Marceau?
Yes.
So it's my understanding, clause number 26, DCCR 0398 is going to be dismissed.
It has been, I've already submitted that.
Actually, that's the new case, Judge. That's one of the new cases.
Oh, I'm sorry.
25-14-13 is gonna be dismissed.
And I have already submitted a dismissal. on
Okay,
this
so
case.
there was a motion requesting an increase in bond in 26 DCCR 0398, but he has not been arraigned or a bond set yet.
And I think my motion says that there has not yet been a bond set. What the state is asking for is because of the gravity of the charges.
But I can't he has to go through the magistration process at the jail. And so let me hold this.
Okay,
What I would suggest is to talk to Judge Requel, who is likely to be the one. And if there's any issues for any of the magistrates, they want to know all the information that there is out there.
okay.
So if there's information that you don't think is going to show up on the public safety report or what they have access to, I would say put that call in. If there's an issue with the amounts of bonds that are set tomorrow morning, then let me know. We can immediately get him brought over and I'll hear this motion. So I won't rule on it today, but get in touch with him and then we can all talk about that once you talk to him.
Okay, thank
Okay,
you.
yes, ma'am. And so we'll reset. Which one is that? My hair's still on my button on the button. And that was on Marceau. Yes. Oh. Okay, got it. Mr. Galmore on Duma Turner,
Judge, I believe it should be a plea, we're just trying to.
I'll hold it.
Details.
We heard from Mr. Doyle.
He was called this morning.
Is Maverick Neal here? If he is here, just have him, make sure he waits outside for Mr. Doyle. Mr. Rennick, you have a Mary Lockhart Fury.
Yes, Judge. She's right. Judge, we do have an update.
Good. That'll be great, I hope. Good morning, you're Mary Lockhart Fury, and Ms. Lockhart Fury has 4 cases, 24 DCCR 1374, 1905, 1906, and 1907. What's the announcement?
This is the latest update from the federal prosecutor. They are making progress.
Okay. That's good. So everything, sounds like they have everything. Now they're just verifying.
Yeah,
And so
and Judge, we had our proper meeting last August. I mean, we don't know why the delay.
Yeah,
Because this is, she has charges in a couple of counties, and we have deals.
no, I understand. And I appreciate you getting in touch with Mr. Moran on that. And so we'll just do.
say 60 days.
Yeah, let's do another 60, and hopefully maybe at that point they'll have the cases at least indicted over there, and then we'll see where we get.
And as soon as we know anything on, of course we.
Thank you very much. Stay in touch with Mr. Rennick. He'll let you know when you need to do that. And then you have, is it Michaelon Skinner?
Yes, Judge.
That's a sentencing?
Yes, Judge. No, Mr. Nichols.
You can try. She needs to get one before this. All right, sir, is it Michaelon? Michaelan Skinner?
Yes.
And Mr. Skinner was previously here in clause number 25 DCCR 1852 and entered a plea of guilty to theft of property. I have received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Judge.
Yes, Your Honor, we have.
Are there any additions or corrections?
No, please.
Nothing really to add, Judge. I understand Officer Weir's concerns. I just want to know for the court, this individual was not identified as the driver. He did participate in the theft and is responsible ultimately for everything that happened, along with the other 2 individuals.
Okay.
But the offer is based on his lack of other criminal history.
Okay, and not the driver of that.
No, Your Honor, a different individual is identified as the driver.
Okay. All right, then, Mr. Skinner, at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is dismissed and you'll never have a felony conviction. So it's great, great opportunity. The other side of that, however, is if you violate any condition of probation. It's not written on here. Is it what level is it?
It's a third.
Is that your region?
So if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you'd have that felony conviction on your record. And you could be sentenced anywhere in the range of punishment, which is between 2 years and up to.
What you just witnessed wasn't a single case. It was a window into the full weight of the American justice system, playing out in real time across one busy courtroom docket. Kenneth Spears stood before the court with a history of state jail felonies stretching back over 2 decades: forgery, controlled substance possession, evading arrest. Now facing a new charge of fraudulent use of a credit or debit card, those prior convictions elevated his exposure to a third-degree felony, anywhere from 2 to 10 years. He pled guilty, acknowledged his record as true, and left the outcome entirely in the judge's hands. Sentencing will come after a full presentence report. No deal on the table, just accountability waiting to be measured. Then came Kalen Skinner, a different story, a different crossroads. Convicted of theft, not the driver, but present and culpable. The judge handed him something rare, a second chance wrapped in a 5-year deferred probation. No felony on his record, if he holds the line. Violate even one condition, and that clean slate disappears. The courtroom gave him the door. Now it's on him to walk through it right. And in between, the machinery of justice kept moving. Bond hearings deferred, federal coordination in progress, cases reset, dockets managed. Because this is what the courts actually look like, not a highlight reel. The real thing. 2 defendants, 2 very different paths forward. One reminder that the decisions made in these rooms echo for a lifetime. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns because justice never gets old.